welcome everyone. So thrilled to have you. We'll go ahead and share the results of the poll so we see who all is here. Got a number of nonprofit attorneys, folks in education, community members, social workers, investigators, CBOs, lots of, and DAs as well. So thanks so much for being here, everyone. We're so happy to have you. My name is Jamie Beck, and I'm the President and Managing Attorney of Free to Thrive, and I'm here with my colleague, Allison Gill-Sanford. And we're looking forward to talking to you about the expansion of California's vacatur law to survivors of domestic violence and sexual violence. And as hopefully many of you know, this is actually the fourth training in a series called Changing the Narrative. So if you have not been able to see some or all of the first three parts, we'll put a link in the chat for you to watch that. We're going to tee this up and put everything into context, but then dive into really what we're here to talk about today, which is how we're able to expand California's vacatur law to include these additional populations beyond survivors of human trafficking. Just as a, for those who are not familiar with Free to Thrive, we are a Southern California-based nonprofit, and we provide legal services and other support to survivors of human trafficking. We also do training such as this to educate the community about human trafficking and trauma-informed practices. And we advocate to change the laws to improve the legal system for survivors of trafficking. So with that, I'm going to turn it over to Allison, who's going to really put this into context for us.
Thanks so much, Jamie. Again, thank you so much for everyone. We were so excited when we saw the just attendance on pre-registration, and I want to encourage everyone, trade emails in the chat. I think one of the utilities of coming to trainings like this is learning who else is in this space, and we need to know each other. I've already seen several folks in the chat that I'm hoping to connect with afterward. So please feel free to reach out to each other using that feature because we're all in different spaces and doing different things, but knowing each other and being able to collaborate really is ultimately a lot of what we need to do what we can in our current cultural moment to get whatever modicum of justice we can for survivors in this space. So just wanted to say that. So we have been in this series about the criminalization of survivors, and I know we have some survivor leaders on here. So thank you for coming, particularly for everyone with lived experience. We're so thankful that you're here, and we really value your presence. And for other folks who have been in the trenches just as service providers and whatnot, thank you also for your presence here. This idea is getting more traction. Sometimes we hear it contextualized as the abuse to prison pipeline. I think that what we have here, Mary E. Gilfus's framework for understanding the way that criminalization of survivors happens, is a really potent expression of it. So it starts with criminalization of the survival strategies that typically women, although not always women, who are experiencing, either domestic violence or trafficking, those survival strategies that are going to keep you alive. First, we have the criminalization of those things, right? Then entrapment into crime or into participating in crime by abusers, or structural entrapment into things that are defined as crimes by gender, race, and class oppression, right? We live in an incredibly stratified society where the resources are kept with the upper echelons. And so entrapment happens through systemic as well as interpersonal means. And then after that process, there is a re-victimization through what we call enforcement violence by the state. So all of the ways that the criminal legal system re-victimizes survivors is a part of that enforcement violence matrix. And another way that I think about this is a lot of the time, the folks we're working with, they've experienced interpersonal abuse and violence, and then go on to experience structural or systemic violence at the hands of the state. So that's what we mean when we're really talking about what is this violence perpetrated primarily against women and girls that, pushes them into this abuse to prison pipeline. That's what we're talking about. Just to put this in context a little bit, these are some stats we have from the Very Institute for Justice. In 2016, they released a large report about the prevalence of victimization that women in jails have self-reported as experiencing. So you can see that the numbers are perhaps not surprising, but nonetheless very disturbing. That over 80% have experienced sexual violence, 77% experiencing some kind of violence at the hands of a partner, and then 60%, so well over 50, half of women in jails experiencing caregiver violence when they were young, when they were children. And this is just the self-reported numbers. So I always think we take this with a grain of salt, because we know that with all of these categories, people tend to underreport. Again, a huge piece of this that we need to acknowledge and express when we talk about this problem is that women of color are criminalized and disproportionately dragged into that state violence part of the network at a much higher rate than their white counterparts. So if you look at kind of the breakdowns here, it's really, really out of proportion to the percentage of the population that any of these demographics represent. And I just want to take a moment to read this poem from a survivor who was imprisoned. I think letting her speak in her own words is powerful. So, my crime, being addicted to alcohol and drugs. My crime, being a survivor of domestic violence. My crime, being a survivor of incest. My crime, being an American Indian woman. I want to land us there as we continue to talk about this issue of the criminalization of survivors, because, I think academia and even people like myself coming from a background where that's not what we've experienced, we can get caught up in the numbers. But what we are talking about is a heavy, heavy human cost, real people having their lives destroyed by this process, right? And having to claw their way back from that if they do get opportunities to, rebuild their lives. And of course, like, some of us have had the experience of being around survivors who have come back from so much, and it's an incredible thing to see. And I don't want to undermine the resiliency and how beautiful that is, but this never should have been something that anyone had to come back from. So a little bit more contextualization here. Why are women in jails? The vast majority are not in jail for nonviolent offenses. The breakdown tends to be property offenses, drug offenses, and public order offenses, which includes things like loitering that are associated with being involved in commercial sexual exploitation. So this is from, again, the VARA Institute. I do encourage everyone to look into their report, Overlooked Women Jails in an Era of Reform. These are our stats. So Free to Thrive clients, we have a way of gathering data about what our clients have been criminalized for. And as you can see from this chart, drug arrests are the largest category, followed by prostitution-related charges, and then theft-related charges. So it really does map well onto what we get from looking at the broader nationwide picture from the VARA Institute. It basically is going to fall into property offenses. That's any theft is going to fall under that, and then the drug offenses and public order offenses. So we see the exact same thing with our clients when we actually get to look at their records. I do want to call attention to, there are some violent felonies, right? Not a small amount. These are still not vacatable. So we'll talk a little bit more about vacature and what we can get through that legal tool. But unfortunately, we are still seeing deep state entrenchment with the criminalization of survivors through the inability of our state to understand that, from our perspective as advocates, we think everything should be vacatable. Like, no survivor should have to live with something that was a part of their life because they were surviving their abuse. So we'll move on a little bit to the legal framework here. I think I'm going to pass it back over to Jamie.
Thanks, Allison. And I did include the VARA report, VARA Institute report that Allison was just referencing in the chat. We'll also include it in the email follow-up with the materials from this training, because it really is a powerful report. So, those of you in the trenches, those of you who have lived experience know this all too well, that having a criminal record creates major barriers to being able to move past exploitation, abuse, and trauma, including barriers to employment, education, housing, public benefits. being able to get loans, and all of that results in financial hardship. It also can cause immigration issues or issues with those who may be undocumented as well. So the criminalization alone causes more trauma and more abuse and oppression. And then what happens as a result of that criminalization, when you get out of the criminal legal system, you still have increased barriers, increased challenges. And one of the many, one of the many data points from the Vera Institute study that is consistent with our client population is the vast majority of women in jail are parents, and they're also predominantly single parents. And so when we talk about these barriers, it's not just affecting that individual, it's affecting entire families and generations. So what can we do about this? What happens when you have a criminal record? What are the paths forward? A really powerful remedy for survivors with a criminal record is called vacatur. And vacatur essentially helps survivors. Very oftentimes the laws are limited to survivors of human trafficking. And in California, as we're here to talk about, it now also includes survivors of interpersonal and sexual violence. It allows them to clear their criminal records that are related to that victimization. And in California, that's actually codified under the Penal Code 236.14 and 15. And we'll take a deeper dive into that in a minute. But first, before we take that deep dive, we want to talk about where we've come from as a country, because it really is, it gives me a lot of hope that there's sometimes when you look at this data and you look at, how big this issue is, it can be really daunting to think about, what can we actually do about addressing these systemic issues in our country. But we've actually made a lot of progress. We still have a lot of work to do, but we've made a lot of progress. So if you look at this map, this is from the Survivor Reentry Project. Oh, go back real quick, from 2017. And if you can't see what each color is, I'll tell you. The orange color is states that have some sort of vacatur law for, and this is specific to human trafficking, this map. So some sort of vacatur law of convictions for trafficking. The purple states have sealing only, which is different from full vacatur, which is completely expunging or removing a record completely, whereas sealing is just, it's sealed, people can't see it, but it still actually exists. And then the blue states are, they have a law for minors only, and the gray states have no law whatsoever. And actually the map even further back, I don't have a map, but from I know around 2013, 2014, when we were advocating, or when I first learned about the vacatur laws, before we started advocating for California's law, there was only 11 states that had vacatur laws. So even between 2013, 14 to 2017, we had a lot of laws passed. And then if you go forward to last year, 2021, you can see it, the colors are different. So I'll tell you what they mean. Yellow is a vacatur law, criminal record relief available for trafficking survivors. The kind of reddish color is relief for juveniles only. And then the gray states have no relief available. That's a huge, huge shift in our country in terms of having some sort of law. And that's the work of advocates around the country pushing their legislatures to pass these laws. I will say the map is a little misleading in that all laws are not created equal. Just because a state has a law doesn't mean it's accessible, doesn't mean it covers all charges or all crimes. So there's a really great state report card done by Polaris Project and Survivor Reentry Project and others. And we can put that in the chat as well, but if you look at that, it gave grades to each state. And so you can actually look up your state. It's been a couple of years since that report came out, but you can see kind of what the ideal is and where we have to go. But that report is really one of the things that inspired Free to Thrive and others to advocate to improve California's vacatur law. So let's go forward. So what did that advocacy look like? So we were absolutely honored to be a part of a statewide coalition last year that advocated for the Justice for Survivors Act, which was AB 124 and authored by California State Senator Kamlager. Now, the goal of this bill was very sweeping. We sought to support survivors of not just human trafficking, but intimate partner violence, sexual violence, and human trafficking
by requiring the criminal justice system to consider the full context of the factors of a person's circumstances throughout the court process at every stage, from when they are first arrested and charged with a crime all the way through sentencing, resentencing, and vacatur. And we wanted them to look at things like the age when they committed the crime, the impact of trauma, the stages of development, and really to understand why, what our legal system, our criminal legal system looks to see if a crime was committed, but very rarely do we ask why. And that's what we were trying to build into California's criminal code. We partnered with these incredible other organizations and had a lot of people with very diverse backgrounds and a lot of folks with lived experience advising our state legislature on what it would look like to bring about justice for survivors and really undo some of the harm that has been caused and create paths forward. So we started with a very broad sweeping bill. As you all know who do this work in advocacy, it did get scaled back, but we still achieved a lot. What I would say is the biggest change that happened in the advocacy process is that the bill originally would have applied to all crimes, and in the legislation, kind of as it was going through the legislature, violent crimes were taken out. So we are still, as a coalition, still working to continue the work that we started with AB 124 to include violent crimes, knowing that as we talked about, there are a lot of nonviolent crimes, a lot of things that this particular population is criminalized for, but there's also a lot of violent crimes out there that we also want survivors who have violent crimes to also be able to get this relief. But what we did ultimately, there's kind of three broad categories of the changes. Essentially, it expand. This is what we did accomplish. So it expands the affirmative defense statute that previously was just for human trafficking survivors, and now it includes survivors of intimate partner and sexual violence. So huge, it's a defense of basically saying, I was forced to commit this crime by my abuser, exploiter. And then next is expanding our vacatur law also to include that same population, which is really powerful. It allows survivors to clear their records in expanding from human trafficking to include intimate partner and sexual violence, and also requires prosecutors to consider the history of a survivor's past in plea negotiations and creating a sentencing presumption. So really at every stage of the criminal process, there were big steps forward for survivors of these crimes. And if you want to know, oh, sorry.
I'm sorry, go ahead, Jamie.
Sorry, Allison.
No, I wanted to add something.
Yeah, no, please do. So just real quick. So if you want to know more about the plea negotiation piece, I highly recommend going back and watching, I believe it's part 2. We took a deep dive into how to put together mitigation packets and talked a lot about what those changes are. So, but today we're really going to focus on that vacatur piece. Okay, go ahead, Allison.
I just wanted to clarify, particularly for those on the call who aren't lawyers or don't have a legal background, the way that this kind of breaks down is like the first point, expanding the affirmative defense. This is a partial remedy for when a survivor is currently being criminalized. Like what's happening is they're up against state charges. They might have a public defender appointed, and that a lawyer can raise as an affirmative defense what has been happening to their client. So that's the point at which this change in the law becomes relevant. The second bullet point is for after the survivor has been criminalized, like when they've gone through that criminal legal process and oftentimes pled out or, in some other way been convicted, we're able to go back and retroactively get things off their record. So that's where that sits in sort of the broader context of the criminal system. And then the last piece is really things that are built in, not so much for defense attorneys and their clients, but for institutional actors in the court system to have to consider. So there's a requirement now that prosecutors have to think about they're supposed to, under this new law, think about someone's trauma and history and what they've been through when they are doing that plea negotiation with the defense lawyer on behalf of the client. And then the sentencing presumption is for the judge to be basically it's to ask the judge to look with the most kind of ameliorative lens on whatever they're going to sentence someone too. So anyway, I just wanted to contextualize that, particularly for the non-lawyers that are on this call.
Thank you, Allison. That's super helpful. I just want to lift up before I hand it back to Allison, who's going to do the next part of this training. Lift up something that Eric Harris said in the chat, which is so important. And thank you, Eric, for being here. He mentioned that Indiana has a vacatur law, but only one HT survivor has had their record vacated. This really shows that laws on the books are just laws until survivors have access to the legal services that they need to help clear those records. And I know Eric and his colleagues in Indiana have been doing a lot of work to help increase that access to justice. But we need lawyers around the country working with survivors to help them use these laws. So thanks for sharing that, Eric.
Yeah, thank you, Eric, and thank you, Jamie, for highlighting that. So we're going to get into the weeds a little bit, and I'm going to do my best to not get sucked into like only using the legal language. So the vacatur statute, we want to help everyone understand like the new tool that we have for vacatur, specifically for people who have experienced intimate partner violence or sexual violence. It's modeled after what was originally Penal Code 236.14, which is specifically vacatur for human trafficking. So the counterpoint that we'll get to in a minute is Penal Code 236.15. So they're kind of sister statutes. But there's 4 elements that someone has to prove in order to get this type of relief. And we're going to talk a little bit more in a minute about what is vacatur and how is it different from expungement. But in California, the way you can think of it is vacatur is the most complete form of relief. It's going to get something actually erased from someone's record. So the 4 elements under that penal code are that any arrests or convictions that the survivor is coming to the court asking them to clear were happening while they were a victim of human trafficking. So a victim, that's very important. It doesn't necessarily mean that the person was actively being trafficked in that time period. It can be afterward that the crime happened, as long as we can tie it to the fact that that person was a victim at some point. So it's easier to get stuff off someone's record if it happened after the trafficking period than if it happened prior to. They have to be nonviolent offenses, like Jamie touched on. That still has not changed to include every offense, although we want it to. And nonviolent doesn't mean necessarily what you would think it means. It's a very specific list under a different part of the penal code, so we'll get there. The crime has to have been committed as a direct result of being a human trafficking victim. Again, we take a pretty kind of liberal interpretation of what direct result means in our advocacy. So things that are fallout from trauma are direct results. And then the last piece is, and I hate this piece, it's like a victim blamey element of the statute, but the person has to demonstrate what's called a good faith effort to distance themselves from, the statute calls it the trafficking scheme, but the life or whatever we want to call it. So those are the 4 elements under the penal code that specifically has been around since 2017 for human trafficking victims to get vacatur. And I just want to talk real quickly about who that actually applies to. So there's kind of 3 buckets that people's experiences tend to fall under if they qualify for relief under that law. The first is if a trafficking period started when someone was a minor, if they were exploited into the commercial sexual exploitation industry when they were less than 18 years old, there is no such thing as consent in that context. And so we don't have to demonstrate anything beyond the fact that they were underage. If they were an adult when trafficking started, then we do have to demonstrate some kind of power and control or coercion, that they were manipulated into being a part of the trafficking scheme. And then the other kind of large bucket is, what we typically call labor trafficking. So forced labor or services is not limited to commercial sexual exploitation. And I do want to say labor trafficking is kind of on a spectrum. Like you can think of it as everything from like wage theft all the way through, sort of having your entire living situation caught up in, like, let's say a forced domestic servant kind of a situation. So labor trafficking can look really different in different expressions. So I just want to go through that. So returning now to 236.15. So again, AB 124, that bill that we were in a coalition helping to run, actually created 236.15. So the version of the vacatur statute that specifically applies to anyone who has been criminalized as a result of intimate partner violence or sexual violence. So the 4 elements are going to sound familiar. That it has to, so vacatur is possible for arrests or convictions that occurred while the person was a victim of either intimate partner violence or sexual assault. Again, victim can be really broad. It doesn't necessarily mean that it has to have been in the acute period where that abuse was happening. It is limited to nonviolent offenses. It has to have been committed as a direct result of the person being a victim. And then this last element, that there has to be a good faith effort by the person to distance themselves from the abuser or the perpetrator of that harm. So those are the 4 elements with the sister statute. So again, I just want to go through a little bit who's going to qualify under this. I will say it's a new area of the law. So what we have here is, you know, basically the definition of domestic violence under Penal Code 13700. So when a person commits abuse against a current or former spouse, fiance, girlfriend, boyfriend, or anyone that they have a child with. But the statute for vacatur specifically says intimate partner violence. And because it's a newer law, we don't know what the courts are going to think qualifies as intimate partner violence. It's probably going to be adjacent to what qualifies as domestic violence under the penal code, but we just don't know. It could be interpreted differently by the courts. Hopefully it will be interpreted in a broad way. And same thing for the element of the statute that applies to sexual violence. So we have just the crime of sexual assault or battery taken from Penal Code 243.4. So it's any just unwanted touching against someone's will for purposes of either abuse or sexual gratification. But again, the new penal code says sexual violence, and that's not necessarily the exact same thing as what's defined as sexual assault and battery. So we have to wait and see what the courts do with that. We, of course, from an advocacy end, will be arguing that this term should apply very broadly. Okay, I do want to go over real quick. So this is for both of these penal codes where we can get vacatur, either on the basis of human trafficking or intimate partner violence or sexual assault. The 4 elements are gonna, look the same. This is the slide that shows you the overlap. But I do just want to highlight as we go through this, that if you're in an advocacy role or you're coming across folks who might be eligible for this kind of relief, to think of it really broadly and think of it really creatively, because really the only ceiling on how we can make the argument that someone deserves and is entitled to this kind of relief is our own lack of creativity in terms of helping the court understand, how does trauma carry over year after year? Like, how might someone's experience in life and their entanglement with the criminal legal system be deeply rooted in what someone else did to them at an earlier point in their life? So, I think particularly for lawyers, it's easy to look at language like this and think like it only fits in this certain box. But I think one of our jobs as we educate courts and try to push the envelope on this issue is to help these boxes expand. So yeah, just a note on that. Also, it shouldn't be confined to the kinds of charges that you might think would happen if someone is either in a human trafficking situation or in a domestic violence situation. Things like drug charges and theft that were coming out of that survival mode, we're always going to argue that they should come under that umbrella and be part of the vacatur relief. Oh yes, nexus. Okay, so this is an important point. The hardest thing often when you have a crime that happens after an acute period of trafficking, or maybe after a domestic violence relationship has ended, is to link the two things. Like, how is it that the fact that this person was a victim of HT or IVP or SA, how is that connected to this crime that's on their record? So that's where I think the advocacy piece really comes in for legal service providers, is making a robust legal argument to connect those things. The farther away in time between, the tracking period or the domestic violence period and when the crime actually occurred, like the more time that elapses, it can be a little bit harder to make that argument. But that nexus is really where I think like there's opportunities for a lot of creativity in terms of advocacy. Okay, just to go over really quickly, what are the nonviolent offenses that are excluded? So again, these are things that are going to be not vacatable, not eligible for this particular form of relief for either if it's based on human trafficking or if it's based on intimate partner violence or sexual assault. So any offense that is not listed in Penal Code 667.5C is good to go. Like we can vacate those. So the list of list of things that are ineligible is all going to be what's housed in that part of the penal code. Anything that was on someone's record as a misdemeanor is going to fall under the nonviolent category, and actually most felonies also. So it's really only a specific list of felonies in that statute that is not vacatable. One thing I do want to highlight is that there is a difference between an arrest on someone's record for one of these violent felonies and a conviction. So the only thing that's not vacatable is a conviction for one of these violent felonies. Yeah. Sorry, I lost what I was saying there, but I hope that made sense to everyone. So we still are always going to, be going into court asking a judge to vacate things that were just an arrest and didn't result in an actual conviction, even if they're on that list of things that aren't vacatable. Okay, and I'm going to turn it back over to Jamie to explain the difference between vacatur and expungement.
Thanks, Allison. So a lot of you may be more familiar with the term expungement. And, it looks like, sorry, we have a question from Dion. Let me just answer that before we move on. Clarify the conviction relief available. It looks like that's actually what we're about to do right now. So that's perfect timing. I think if I'm understanding your question right, Dion. This is really like what happens if your record is vacated and what's different about a vacatur versus an expungement. And again, everything we're talking about now is specific to California law, so maybe very different in other places. I know in some states, vacatur and expungement really are the same thing, but in California, there's actually really important distinctions. So the first thing is, kind of what types of cases it's available for expungement, which is also considered setting aside, or a dismissal. It's available for any convictions that do not result in a state prison sentence, and there are some exceptions to that. Vacatur is available for nonviolent crimes regardless of the sentence or disposition. Also, there's a completely different legal standard. For expungement, it's mandatory in some cases, and in other cases, there's an interest of justice requirement. Now, vacatur has a pretty high threshold. It's actually a clear and convincing evidence standard. So if you think about the different standards in our criminal system, a preponderance of the evidence is just over 50%. So 51% is preponderance of the evidence. And beyond a reasonable doubt it's beyond a reasonable doubt, the conviction standard from a jury trial. Clear and convincing is somewhere in between those two. It's not beyond a reasonable doubt, but it's a lot higher than preponderance of the evidence. So knowing that this is a pretty high threshold that you have to reach, which means in order to persuade a court to essentially wipe away your record, you have to be able to really establish, all the elements in order to get this relief. And there is also this, the best interest of the individual and an interest of justice standard that's also part of vacatur. The type of relief is also different. So in an expungement case, the ultimate result of the expungement is the person is released from penalties and disabilities. Now, the reality is at the end of the day, there will be on your criminal record, if somebody runs your rap sheet, if an employer runs your background check will come back and it'll have the charge and it'll say dismissed. That's where that set aside and dismissal comes in. For vacatur, the offense is deemed not to have occurred. And the ultimate result of that is that it actually is removed completely from your rap sheet. One of our colleagues refers to it as a big eraser, and I love that image of a big eraser, erasing away those crimes that survivors shouldn't have ever been charged with to begin with because they were a victim. All right, we can go to the next slide. So there's a little bit more to this. Some of the other differences is the impact on your record. So if your record is expunged, it actually remains a part of the public court record if somebody runs an FBI or state background check. And that's what I said about that. It'll say a dismissal. So it's still there. Whereas for vacatur, the statute requires that the record is sealed immediately and destroyed within 90 days. And it says as of January 1st, 2022, this is actually a really exciting change to our vacatur law. Another bill that Free to Thrive and other partners worked really hard on was work to make different updates to the vacatur law. And one of them was to shorten the timeline for sealing and destruction of the record. So that is now a lot shorter than it used to be. 1 year for sealing and 3 years for destruction. And now it's immediately and 90 days, which we're very happy about. Next is what you have to disclose if your record has been expunged or vacated. So if your record has been expunged, you are still going to be required to disclose that in certain circumstances. A lot of states, including California, have banned the box, which means it can't be in an application for a job asking whether or not you have a record, but employers certainly can make an offer of employment contingent on a successful background check. And the question that they may ask is, have you ever been arrested or convicted of a crime? And if a question that broad comes up and your record has been expunged, you still would have to answer yes, even if it's been expunged. With vacatur, you can actually deny ever having been arrested because it is deemed not to have occurred, which is incredible. And lastly, for licensed professions, you think about how many professions require a professional license. It's a lot. It's real estate, most things in the medical profession, obviously practicing law, and the list goes on. Being a massage therapist, there's so many different things. In California, an expungement, it can still essentially your expunged record can still be considered by licensing agencies. And I definitely have seen that come up for folks looking to get licensed, that they had some old criminal background, and even if their record was expunged, it still popped up and it still was a barrier for them to get a license, to get that license. Now vacatur, the record of that charge cannot be distributed to licensing agencies, and there's no requirement that you disclose it. So this is, again, just think of vacatur as a big eraser. So how do we help survivors get this relief? This is really exciting. This is a very, very powerful tool in our toolbox as lawyers and advocates. So the first thing is to help a survivor find a vacatur attorney. Now, it is certainly possible to get your record vacated without a lawyer, but it is a pretty complex and arduous process. Unfortunately, I wish it was a whole lot easier, but because of that clear and convincing evidence standard, there's a lot of hoops that survivors have to jump through to get their records vacated. And so it definitely helps to have a lawyer helping you. And if anybody is looking for a vacatur lawyer, if somebody has a record in Southern California, Free to Thrive is taking survivors, helping them find a lawyer or representing them with folks with records in Southern California. And with Northern California, we have other partners, including Justice at Last in the Bay Area, who can help with those as well. And if neither of us can help, the Survivor Reentry Project is amazing at finding lawyers, not only in California, but nationally. So once you have your lawyer, or even while you're trying to find a lawyer, the next piece is to draft a narrative of what happened. And this really is the main part of the vacatur petition, is it's essentially telling your story. And a really important part of that is addressing those different pieces of the elements that Allison went through earlier. So I'm a victim of human trafficking, and sharing in your story, what happened in your life that led to you to becoming a victim of human trafficking. So with our clients, we really start from the beginning of where they grew up, what their life was like early on in their childhood and their development, how they first came to meet their trafficker, what that relationship was like. And then I'm a victim of human trafficking. I have nonviolent charges related to my trafficking. So talking about what charges you have, connecting them with what happened to you, your exploitation or your victimization. I've removed myself from the trafficking scheme. I'm no longer in that life. So how you got away from that situation and what you're doing now. And really that's by far the best part of the story for the clients that we work with is what they did to overcome that experience and where they are now. It's as Allison mentioned earlier, it's pretty incredible what so many survivors have gone through in order to move forward with their lives. And this is really hopefully something that is really empowering at the end of the day. The process itself can be unfortunately pretty re-traumatizing. And we talk a lot about we are trauma-informed lawyers in a legal system that is not trauma-informed, unfortunately. And it results in having to go back through that past trauma and relive it in order to tell your story. But what we find is while the process itself can be really re-traumatizing, the ultimate relief can be very healing for our clients because they tell this whole story. And ultimately at the end of the story, the result is the legal system saying you are a victim of human trafficking, you're a victim of interpersonal violence, of sexual violence, and your record does not define you, and you shouldn't have been charged with a crime to begin with. That shouldn't be a part of your narrative because you are not a criminal, you are a victim. That's ultimately what that relief is saying to people and giving them that path forward that we talked about, all those barriers, of removing those barriers. So essentially that's the process. There's a lot more to it, and we have trainings that take a much deeper dive into how you put that narrative together, how you help work with somebody to draft that narrative, what are the other components of a vacatur petition. And we're not going to take a deep dive into that today, but really just tee this up for further discussion. But note that if you are either wanting to take a case or wanting to work with survivors and help them, that we're happy to offer further training on that topic. So what's the ultimate relief? We at Free to Thrive like to think of vacatur as opening doors. It helps result in better employment opportunities, access to safer housing. It removes barriers to education. It also helps survivors regain custody of their children. Unfortunately, oftentimes their criminal record is used against them by the same people who helped them incur that criminal record or force them to commit those crimes. They then in family court try to get custody of their kids and say this person is a criminal, they're not a fit parent. So clearing that record is a really key piece of helping regain custody of children. And it also can lead to increased opportunities for community engagement. We've had a number of clients come to us who wanted to volunteer at their kids' schools, and they had never disclosed their past to their spouse or partner. And it only came up when they had to go through a background check to volunteer at their kids' schools, and having to relive that history and that trauma simply to be able to volunteer at your kid's school, to be able to do things like get a job and get housing is just, it's so ridiculous and so unfortunate. But what the ultimate result is that it allows them to do those things that they want to do without having that barrier of their criminal record holding them back.
So I want to take a minute to go ahead and introduce the VACATUR Attorney Network. So this is a network that Free to Thrive runs, and the whole point of the network is to try to gather together and equip attorneys who are using these vacatur laws in California. So we have folks who are, service providers at legal aid outfits, folks who are in private practice or at firms or retired who are our volunteers who are a part of this network. And really what we do there is we share resources and we provide technical assistance and training. So if you are at all interested or know an attorney who might be interested in getting involved in this, please become a part of our VACATUR Attorney Network. You can find the sign up on our website. And we just host regular discussions and workshops, and you can access all of our past trainings. So we cover things like client interviewing for that substantive declaration that Jamie was talking about. You know, in that clear and convincing evidence standard, the strongest piece of evidence we have, like what we have to convince the court of, is it's about 75% likely that this person went through the things that are in their declaration, or the way that they told their story. And so the primary piece of evidence that we use to convince the court of that standard is the client's story, the survivor's story, as they remember it and as we've written down. So we equip lawyers in the Vacatur Attorney Network to be able to create that primary document that's going to help their clients get this relief. There's a lot of nitty-gritty and idiosyncratic issues with how to file in different counties. And so we are learning that, and we are sharing our knowledge as we go. And ultimately, the goal of VAN is to have a statewide network where we can refer survivors throughout California. So, you know, having someone in Ventura who can do vacatur for a client or file for them there, even if we met them in LA or something like that. So yeah, that's the ultimate goal of VAN, but it really is where the work is happening on the ground. So if you are interested in vacatur, please feel free to get involved there, and you can look at our past trainings and start coming to our upcoming ones. Typically our structure is that every month we have a training on Mondays at 5 to 6 Pacific time, and on those off weeks we still meet every Monday after work hours. But we just have office hours. So anyone can pop in and talk to myself or Aaron, who runs our vacatur program, to workshop any issues coming up in cases and ask questions. And we're also available outside of those hours for support. So, yeah. So if you are interested in more detailed trainings, technical assistance on vacatur matters, or consultations, please get in touch with us. You can request a training on our website or email us there. You know, part of what we want to do with this series, and part of why we were highlighting the results of AB 124, is we really want, you know, we're an anti-trafficking org, but we really want domestic violence and sexual assault service providers to know that vacatur of criminal records is an option for your clients. And we just want to spread the word, and all of the tools that we've used to understand how to do vacatur for trafficking survivors are going to apply to doing vacatur that's based on intimate partner violence or sexual assault. So we want to spread the word and equip and train folks to be able to make that form of relief accessible to all survivors who are eligible now.
All right. Here is our contact info. We're going to launch a survey for those of you looking for MCLE credit. We're going to ask the survey so we can capture your information and send you your CLE certificates. And so we'll go ahead and launch that poll now. While we're launching the poll, if you could go ahead and ask your questions in the Q&A, we'd be happy to answer them. We do have time reserved now to do some Q&A. So but please respond to that poll if you want to get that CLE certificate. I see we do have a question from Dion in the chat, so I'll answer that one first, and then we'll go over to the Q&A. So the question is, if there are some cases that are not eligible for vacatur, but some are and are vacated, what's the best response for a survivor to admit on an employment background check? So I'm happy to answer it, and Allison, feel free to add anything, but my thought would be, once the record is vacated, the charges that are vacated will be removed from the background check. So if an employer runs that, they're not going to see it, with a huge asterisk next to that, that there is a very arduous process that we go through after we get that court order to get that record actually removed from their DOJ and other records destroyed. But when that happens, then it's not going to pop up. So the survivor will know that what they do need to disclose, I mean, it's usually what's going to happen is it's going to be disclosed for them through a background check. But if an employer is going to, you know, come back with questions or anything, or potential employer, it should be about the remaining charges. And if they're in this kind of limbo stage where their record has been vacated, but it's still showing up on their background check, then one thing that our clients will often ask us for is a letter, basically just saying that their record has been vacated, and it, it shouldn't essentially, shouldn't say it shouldn't appear on the record, but just letting potential employers know the record's been vacated. Allison, do you have anything to add to that?
Yeah, I think so I think what Dion is raising is sort of a tricky situation where a survivor has had maybe even the majority of their record cleared, or a lot of things vacated, and there are still things on there that aren't vacatable. So let me back up and say a couple things. So I think the power of vacatur is like what Jamie was talking about with the big eraser. Even though factually it happened, like you were arrested and maybe you were convicted, legally after vacatur, you're legally entitled to say it never happened. So there's a difference between what happened in actual history and what happened legally. And so after vacatur, you can say, I'm legally entitled to say this never happened to me. That's not going to be true for something that didn't get vacated. And so it's going to depend on the way the question is worded. Like, for example, if the question from the potential employer, for example, says, have you ever been convicted of a felony? Let's just say a survivor has a record that we got all the felonies vacated, then they can answer, no, I've never been convicted of a felony, because that's legally true. But if they've still got maybe a misdemeanor conviction on the record, and the employer runs a background check, that's going to crop up and probably in the least be a conversation. And so I think it depends, like, to try to answer your question, Dion, it depends on what the person's being asked. If they're asked something that's narrow enough to fall under what was vacated, they can say, this never happened to me. But if the question is really broad, like some questions are like, have you ever been arrested? Only if every single arrest on your history was successfully vacated can you answer legally no to that question. Otherwise, the survivor would have to answer yes to that question. So there are still limitations to the relief. And another thing I will say is, I think this is a little bit case by case. Like if we had a client who was struggling with how to answer one of those questions and had a form, like we would be happy to look at that form with the client and help them understand what they can legally say. A little trickier if it comes up in an in-person conversation, but yeah. Thanks, Jamie. So we do have time reserved for questions. And again, just want to reiterate that we're really trying to get the word out there about vacatur specifically so that more folks can get this relief that they're legally entitled to. And if we have any, thoughts or questions from the audience, we'd love to take some time to respond to that. Also want to be cognizant of everyone's time. It's almost at the hour, and if folks need to drop off, feel free. If you did the MCLE survey, you'll still be able to get MCLE credit from attending.
And just a few things from the chat. Someone mentioned that it looks like the VAN link is broken on our website. Sorry about that. We're making some updates and a few of our links are not working, but I did put in the chat, really, this is where you sign up for VAN. So just fill out that form and you'll be added to our VAN list and get information about future meetings and trainings. And then someone else asked, how do we join future trainings, have access to information from previous sessions? So for information from previous sessions, all of our past trainings are on our website under trainings, past trainings. And we also put a link specifically to the last 3 parts of this, or the first 3 parts of this training already, but we can add that link again as well. And so go look on our website and we'll put the link in the chat for past trainings. And then for future trainings, so after attending this training, you'll be added to our trainings email list and you'll get notifications about future trainings. If you want to get all of our emails, not just emails about past trainings, but really knowing kind of what Free to Thrive is up to, learning about our clients and our cases and our work, you can go to our website and sign up for our email list. If you go to our website, there should just be a pop-up window that'll ask you if you want to join, but if for any reason it doesn't, you can just scroll down to the bottom of the page and join our email list there. And then you'll get all kinds of information about what we're up to. And I see another question from Dion in the chat. What is the current status of federal vacatur? That's a great question. So there have been currently, the current status is there is no way to vacate a federal crime from your record, unfortunately. There have been sorry, I'm trying to read the chat at the same time. There have been multiple bills brought in the in Congress to bring a federal vacatur law. The last two times the bill didn't really go anywhere, kind of just died without making it too far in the process. There's another bill that I understand should be coming out any day now. I've been hearing that for a little while, so I'm hoping it's coming soon. That will be a federal vacatur bill. And it's really going to take a whole lot of advocates pushing for it, because there's just a lot going on in our country right now, and this topic just hasn't seemed to get a lot of traction the last few times. And so I'm really, really hoping that we can generate a federal movement to pass this law to get this relief for survivors. Last I heard, the current version of the bill also included an affirmative defense, which would be a huge additional relief under federal law to have an affirmative defense for human trafficking. So definitely keep an eye out for that, and hopefully we'll see some movement this cycle.
I just saw Ashley's question. Ashley, can you clarify? I'm not really sure what you mean by a wait time. Do you mean to work with an attorney with Free to Thrive, or is there any
You mean like
clarification?
from the time that you've left the life or the trafficking situation? Is that what
Oh,
yes. Okay. Thanks. Do you want to go ahead, Allison?
sure. There's no wait time under, so there's basically the answer is no, you don't have to wait at all. And actually we are, we are working on some partnerships where we're trying to put feelers out for if it would be possible to have someone who's currently being criminalized actually receive vacatur relief when that case is dismissed. That's something we're working on at a court in LA. So that would be sort of a time period of 0. There's no real time period where the person has been away from that criminalization, and then we're trying to see if they could be eligible for vacatur. It's very case dependent. You have to keep in mind that one of the elements right now of the statute is demonstrating distance from the trafficking scheme or distance from the abuser, if it's the 236.15 statute that you're using. So it is hard to demonstrate that element without there being some lapse in time between like an acute trafficking or an acute abuse period and when the person actually brings their petition for vacatur. But it doesn't mean that someone necessarily has to wait. It's just a consideration of how do you demonstrate that factor if there hasn't been a lot of time that has passed.
And it looks like Andrew's asking about pre-sentencing. If the case is still ongoing, I would look at the other pieces of AB 124, and we're happy to talk to you offline, Andrea, about that particular situation and what jurisdiction it's in, and connect you to resources. But also I would look at the past trainings, particularly part 2 of this series that has to do with plea negotiations and mitigation. So, but it's interesting, not for an open case. For an open case, it would be more likely, ideally to use the affirmative defense or the provisions related to plea deals. But if for somebody who still is in custody, still kind of serving their time or still on probation, as Allison said, it may be possible to vacate the record even at that point. One of our colleagues out in Florida, Brent Woody, doing amazing work at the Justice Restoration Center recently, was able to vacate a record for a survivor who was in prison. Now, it's a different state's law, but I am very inspired by that work and feel like with the right facts in California, we could try to do the same. And certainly for somebody who's on probation, I feel even more strong than somebody who's out of custody that they should be able to vacate the record if they meet all the elements. So again, it's a case by case, but I think it's possible. So, but thank you.
I want to
so
answer
much for these
another.
Questions. Yeah, go ahead.
Yeah, another part of that I just want to make sure everyone knows is a lot of statutes for post-conviction relief have like what's generally deemed a timeliness provision, like a window of time in which you have to bring the petition for relief. We are very lucky that these statutes don't have that. And actually the only commentary that the statutes have on timeliness specifically says, there are safety considerations for when someone even feels like for them or their family, they could go back to court and say, hey, this happened to me. So there's almost a presumption of it can take a really long time for someone to be ready to go ahead and try to vacate their record. So in addition to there not being a clear time period you have to wait before you're eligible, there's also not a ticking clock that means that at some point you won't be eligible to petition for this. So it can be 20 years, 30 years in the past, and you can still be eligible.
I'm not seeing any other questions. If anyone has any burning questions, ask them now. And if not, we'll go ahead and wrap up. But thank you all so much for joining us today. I hope you learned something. I hope you'll take this back to any colleagues or other folks you know in the space to learn more about this amazing relief that's available. I know some people have been asking, will we get the slides? Will it be recorded? Yes, we're recording it. We will definitely be sending you the recording along with the slides following this, and also some other materials as well, including some of the things that we put links to in the chat, information about joining VAN. So keep an eye out for that email. And you can always, just so you know, you can always check our website anytime. If you miss the email or anything, we always post our past trainings on our website. So you can always go there to watch not only the most recent ones, but other ones as well. So thank you so much for being a part of this. And it's just so great to see so many of you from all around the country being part of this conversation with us. And thank you, Allison. You're amazing. And have a
Thanks,
great
Jamie.
rest of your day.
You will get a cheat sheet on AB 124, so that the key points that we hit are going to get emailed out to you afterward as well on what that changed. So yeah, thank you again for everyone for coming. Do not hesitate to email us if you have any questions. I will say, maybe for the sake of Jamie's inbox, because she's got so many, like, please CC me as well. And if anyone needs further help or input, we would love to chat with you. Okay. Bye, everyone.
Thank you. Take care.